Good morning, Mr. Rojas.
Good morning.
This courtroom hearing focuses on Stephanie Moore, who is facing a probation violation tied to a prior robbery conviction. The court is reviewing whether her probation should be revoked after a reported 7-year period of absconding. Both sides acknowledge the complexity of the situation, as the judge must weigh time already served against long-term non-compliance. The key issue is whether the defendant's actions justify a prison sentence or continued leniency.
Good morning. You are Stephanie Moore?
Yes, ma'am.
And so Ms. Moore is here in cause number 11-12536, on probation for the offense of robbery. That probation was from December 8th of 2011. And we were here. She pled true to count 1, 2, and 3 in that motion. I've received an updated pre-sentence report. And has everyone had an opportunity to review that?
We have, Your Honor. I have, Your Honor.
That also includes a letter from Ms. Moore and a substance abuse evaluation as well that was done at one point. Do y'all have that as well?
I do, Your Honor. Yes.
Okay. So this is open to me, and I know we all understand the predicament that we're in. I mean, I have two choices. I can revoke or it just goes away.
That's correct, Judge. And with a 7-year period of absconding, I don't know what the right answer is. I did look up, and I'll note for the court that she's been in jail 111 days since this motion was filed, or since she was apprehended, and a total of about 270 days on this case. I just think we can't ignore that period.
At this stage, the defense presents mitigating circumstances, arguing that Hurricane Harvey in 2017 significantly disrupted the defendant's life. According to testimony, severe flooding and lack of support from probation officers contributed to her failure to report. However, the court must determine whether these hardships legally excuse years of non-compliance. This moment highlights the tension between personal circumstances and the strict obligations of probation under the law.
Of just abandoning probation. I'm not advocating for a heavy sentence, but I think revocation is what we kind of have to do here.
I don't disagree.
I understand if the court feels differently, but that's...
No, I don't think I do, because I mean, it looks like, I think that's just kind of rewarding some really bad behavior.
I understand that, Judge. I think from Ms. Moore's perspective, I mean, she had been going along up until 2017 doing relatively well on probation. She tells me that in 2017, when Hurricane Harvey came through, she just had 20 feet of water in her house, and she just spent the rest of that time trying to recover from that. I think
I did call my probation officer and try to get him to help, but he never even came out to my house or nothing. He didn't help me get any kind of mental health help or anything. And I called my old one, which was Miss Sally, and nobody came out for help.
You were on the mental health initiative caseload.
The court reaches its final decision. After reviewing the plea and evidence, the judge formally revokes probation and sentences the defendant to 3 years in the Texas Department of Corrections, with credit for time already served. The ruling underscores that extended violations cannot be overlooked, regardless of circumstances. For more real courtroom breakdowns and legal analysis, be sure to like, subscribe, and follow for future case updates.
You've been to Franklin House South, the Oxford House for Women.
Yes, I was the president there.
Through the ATAR program,
Yes,
through
ma'am.
Right Choice, through SafeP,
Uh-huh.
and you were a resident at some point at the Jefferson County Women's Center.
Yes, ma'am.
Okay. I mean, that sounds like a lot of help.
I did. Well, I did all that and did good with all that.
Okay.
Yes.
Okay. Anything else?
No, Your Honor.
Judge, I think, I know the court doesn't like to do this, but I think there may be another option. Maybe if the court, because one of the allegations is that she's behind on her fees.
I'm not worried about that. I'm worried about 7 years of doing whatever she wants. And I understand that Harvey affected a lot of people, but then you get over whatever is happening and you go see your probation officer.
Okay.
You don't just stop
Yes, ma'am.
for 7 years. Okay, I'm going to find in, that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of robbery. I'm going to sentence you to a term of 3 years in the institutional division of the Texas Department of Corrections.
Okay.
You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I need y'all to sign this. I'm going to, this is the trial court certification, if you'll get her signature that she's getting a copy of that real quick, please. Thank you for being here, Ms. Joseph.
Thank you.
Sorry, I didn't ask you if you had anything else to say. So you're going to get a copy of this, which shows that this was not an agreement, and so you do have some rights to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Yes.
Good luck to you, ma'am.
Okay, so I'm looking at the indictment on this one. Are any of these prior thefts actual third degrees or higher, or are they all enhanced because they're state jail felony with prior thefts? Because if they are, I don't think we get to the second degree.
You don't?
I don't. I feel like we've talked about that. I think you can't enhance and then enhance again. Unfortunately, I don't necessarily agree with that law.
I think it is, they have to have another felony other than.
It's my understanding that if it's a misdemeanor theft that's enhanced to a state jail, then it can't later be used to enhance another misdemeanor
Unless it's a different
enhanced.
felony.
It has to be either a regular
Right,
felony
right.
of any type. It can be a
Right,
theft,
right.
but it has to be a regular felony theft,
Right.
or it has to be a regular felony of some other type, which is unfortunate in my
So in
opinion.
my notes, Judge, just if I may, and I would be happy to go back through and map all of these priors out. It looks like when I originally reviewed it, I made note to myself that she had at least two misdemeanor thefts that were enhanced to state jail with sequential regular felonies.
Okay.
But if the indictment doesn't reflect that.
Well,
maybe
I don't
that-
know if it does, because the indictment doesn't list them like that. It just says theft. It doesn't have the degree. So
Right.
I would need, if we're going to go through the indictment, if you can hold it while you check which ones might be real felonies.
Yes, and in light of that, Jim, since she's going to reject, I think it's very clear that it's a third degree. My offer was a 5-year cap, so that would be within a
But I don't
third
know
or
if-
second.
I don't know
But
if
I
it
know we
is.
need to admonish her.
I don't know if it can even be a
A third?
third unless, let's
I'll
look
check.
at it. I feel like, I don't know, I feel like we've done this and then I forget again and then I go back through it, but, okay, I'll hold it. Yeah, double check if it can be either.
Okay. It might take me a minute.
Yeah, because I think if they're all enhanced,
I
then
think,
it doesn't matter if it's a second or a third or whatever it is, unless they're real felonies, I think. But y'all double check me, please. And if you have the real felonies, that makes it easy.
Right.
Instead of the enhanced ones. Okay, just go back with the bailiff for a minute, ma'am. Let's see. Good morning, ma'am. Are you Veronica Randall? Yes. And Ms. Randall, in cause number 25, GCCR 0246, you're charged with the state jail felony offense of theft of property with previous convictions. That's from November 21st of 2024. Your indictment alleges you were previously convicted of theft April 4th of 1984, April 11th of 1985, April 10th of 1989, November 12th of 1991, October 10th of 1994, May 6th of 1999, April 17th of 2008, August 24th of 2015, April 29th of 2016, November 28th of 2016, and then February 11th of 2019. And what that means is that
There's
Judge, you
Also,
allowed us a little bit of time last week. with
Yes.
This issue. I feel like just to be on the safe side, we have marked third degree. I've gone through the priors. There's a lot of underlying misdemeanor priors that some of them, to be quite candid with the
There's
court, will
robbery.
be difficult to prove up due to the age of the prints.
Okay.
So I think it's probably safe to say it's at least a third, if not a second. Based on this offer, we would move to proceed on the third at this time. If this is rejected and we do get on the trial docket and I have a little bit more time for Mr. Robinson to look at those prints and we make a determination.
And there are other ways other than prints. I mean,
Correct.
those can be proved up even if there's no prints, as long as there's.
I will give appropriate notice when it's
Okay.
placed on the trial.
So, Ms. Randall, what that means, as you heard, is at least for you would be facing punishment of a third-degree felony if you go to trial and you're found guilty, which is between 2 years and a 10-year punishment, with the possibility of it being a second-degree felony, and that would be between 2 years and up to 20 years. Do you understand? And then in cause number 25 DCCR 0247, you're also charged with theft of property with previous convictions. That's from November 16th of 2024. Same prior offenses are alleged in that indictment. Same thing with regard to punishment. Do you understand?
Yes.
And then in each of those cases, I have here on the computer plea bargain rejections that you've signed with Mr. Parker that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for 4-year terms in the institutional division of the Texas Department of Corrections. I want to make sure you understand what your possible consequences are and what your options are. And do you understand all of that? And do you want to reject those offers and have your cases set for trial? And Ms. Malfino, is there any reason to believe that these offers would change?
No.
I want to make sure you understand, Ms. Randall, that after today, I will not accept these plea agreements. Once your case goes on the trial docket, it's going to be tried in front of a jury, or it would be a plea to something other than this, but not less. Do you understand? Okay, and I will get your case set on the trial docket. Mr. Parker has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? Mr. Parker, you're released. Ms. Randall, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. Okay?
Judge, just if I may, for the record, in addition to providing notice of whatever enhancements I can, I would also most likely file a motion stacking these sentences.
So I want to make sure you also understand, because these offense dates were different dates, that if you're found guilty in each of these cases, the state can request that any punishment